Hello, I'm Judge Sally Willett, retired. I'm going to give you a presentation on rights of way. Indians are being had big time. Let me give you a bit of my background. In 5 months, I will have been in Indian law for 50 years, half century. I've been in Indian probate and land law, actually Indian probate for 43 years. I'm a former educator. I have a master's and bachelor's in foreign languages and education. I've taught in the US and in South America. That's enough about me. What I'm going to present to you today are the problems basically everybody is not seeing with rights of way, and there are a lot of them. I had some very good news. I'm going to switch the slides now. I have always done visuals as a former educator for the landowners because they need to be able to understand things visually. Words, a wall of words does no one any good. But I'm going to begin because we had some good news today about the Tesoro pipeline out of Fort Berthold when the Department of Interior was trying to lowball the landowners. That order has been vacated. Tara Sweeney's order has been vacated on March 3rd, 2021. And they're basically going to do a redo. I'd like to point out to you that the secretary does not have the ability to lowball the landowners. There's not only a duty of loyalty and care to make trust property productive, they have to preserve value. If you look at the last line, take affirmative action to preserve value. This was out of Willett's office in 1978. I was in the Department of Interior in that year. So I want you to take this duty very seriously because the government has twice tried to lowball the value of the entire allotted land base since 2005. We'll get into that later. This is, I quickly created a slide. The decision vacating the Tara Sweeney order says Indian landowners are entitled to appropriate due process. Here, it does not appear that the parties had a full, fair, and reasonable opportunity to be heard regarding the decisions that were made on July 2nd, 2020, January 14th, 2021, concerning the expired right-of-way occupied by Tesoro. The Tesoro, I've left off the rest of the caption, Tesoro versus Great Plains Regional Director, BIA, order vacating prior decisions. This is extraordinarily good news. It's almost as good news as the McGirt decision, not quite. We're going to give you context now because there are many different types of rights of way. The first rights of way that affected Indian country were railroad rights of way, and they are in the treaties that were signed. This is probably the most impactful, and these are the pipeline rights of way for which there is corporate abuse of public process for private gain. We will be discussing that. Cushing, Oklahoma is down where the dot is, and this is what the pipeline system in the United States looks like. And it's like Swiss cheese. It leaks like a sieve. This is probably the most important or the most known of the pipelines, and that is the Keystone. This is the upper Keystone system. Now, notice that Fort McMurray is the site of the dirtiest oil on the planet, tar sand oil. The intended market for this oil is Asia. Notice that would be west. But if we go to the next, slide, we're going to see that they're not going west. I know virtually nothing about math, but I do know the geometric principle. The shortest distance between 2 points is a straight line. Now, why would we be transecting the United States from Canada all the way down to Texas? We're doing that because the Koch brothers own refineries down there. And so we're going to go all the way out down the center of the United States to a refinery in Texas. And let me show you the impact of that. This is the Oglala Aquifer, and it's a huge aquifer. But it isn't just an isolated groundwater table. It also feeds the largest expanse of agricultural territory in the world, and that is the Great Central Plains grasslands. So I'm going to go back quickly. I'm sorry. I'm going to go back to the Oglala Aquifer. The here's a dirty little fact about the pipelines. They're not maintained. It costs $1 million a mile to run the pig. That is the apparatus that checks the leaks. They have it calibrated too high because if they calibrated it low enough to fix the leaks that were non-damaging, it would cost them a lot of money. Their business model is to buy insurance and let the insurance companies duke it out. I know this because my father died in a nuclear power plant accident, and we discovered how their business model operated when they tried to litigate my mom into the ground. So what we are is a sacrifice zone. You wonder why the market is Asia. We're yesterday's news. They have a 500 million population of middle class, expected to go to 1 billion in short order. So we've become the new Africa. The corporatists are sacrificing us for market share. This is what the grid system looks like currently. This is another right-of-way system. This is what it's going to become. This is going to be the expanded power system, and you can bet your bottom dollar that indents are going to be tapped on that one. Kurt Kickingbird and Karen Ducheneau in the 70s wrote a book, something like 100 million acres of land. Indian lands are always the first choice to condemn. Now, you need to know, in order to understand why this is important to Indians, we only have 2% of our land base left of all that was owned. We have, and these are round numbers, approximately 56 million of trust and restricted land. 20% of that, 10.7 million, are allotted, and 20% of that are off reservation, which the American Indian Probate Reform Act has going to fee very fast, because they're using 3 of the 6 methods of termination. That is to get rid of people so that it gets rid of land, and it gets rid of services, which includes getting rid of administrative duties. 20% of all undeveloped energy resources in the United States are located on Indian land. We know this from Russ O. Swimmer's writings, and I will give you a spoiler alert. I have no good words about Swimmer. We know that there is a kleptocratic move going on because on December 5th, 2016, in Reuters, there was an article published. Trump advisors aim to privatize oil-rich Indian land worth $1.5 trillion. Privatizing is another name for expropriation. Interestingly, Representative Mullen told Reuters that Indians do not own their own land. I don't have words for the paucity of knowledge of this individual. His own tribe holds its lands since removal in fee simple absolute, subject to restrictions on alienations. We're not dealing with rocket scientists at the helm here. But the big warning is corruption and incompetence. They're a lethal witch's brew when they get together. Matt Taibbi is an excellent writer. He used to work primarily for Rolling Stone, and he basically focuses on corporations' abuse of power. And he calls corporate America the great vampire squid that relentlessly jams its blood funnel into anything that smells like money. Well, guess what smells like money? 20% of the remaining undeveloped Indian of energy resources, and Indian lands are the prey. So you have to be aware of that in everything you do in the future. Now, I use sometimes for myself, because it can be pretty aggravating, I tend to use humor when I'm teaching in my classes, because otherwise it might throw something. But I always think of Charles Koch. When you look at the Viking, I always think of Charles Koch when I see this. And the attorney, you can tell it's the English system because they're wearing wigs. The attorney says, Your Honor, my client was simply expanding his business interests. We object to the use of the word pillaging. Well, Charles Koch, Koch Oil, which is a subsidiary of Koch Industry, stole over $30 million worth of oil from the Osage by theft at the gauge. And this is, go to the box in the left lower corner. He was recorded by a gauger, one of his own employees, wearing a wire for the FBI because the gauger got caught under surveillance. The gauger asked Koch why he was stealing from old Indian ladies, and Charles Koch actually giggled like a teenage girl and said he just wanted his fair share. That's all of it. You can see the quote in Billionaires and Bandit Ballots. The Kindle location is approximately 342. Now, we know on General Sherman, the only good Indian is a dead Indian, that he was not a friend of Indians. But even he had awareness of what was happening to Indians. He defined a reservation as a parcel of land surrounded by thieves. He was correct. Now, we're going to get into the sum and substance. The right-of-way statutes are all in Chapter 8 of Title 25 United States Code. The statutes that were created during the 1899 and 1928 period are sections 311 through 322. In the 48 Act is sections 323 through 328. I commented upon the most recent set of right-of-way regulations in which it was implied in the explanation that the 48 Act preempts the earlier statutes. I do not know how someone could have written that with a straight face. Section 326 of that act says that no modifications, changes, or alteration of the preceding statutes was to occur by the 1948 Act. But the important point here is that the oil corporations are using 25 U.S.C. Section 357 to condemn allotted interest. That statute was passed in 1901. 321, which is a pipeline statute that authorizes the secretary to approve pipelines, does not allow judicial creation of pipelines. Now we're going to go through the triage, which is the ranking of importance of bad things that are happening. Oil corporations have integrated systems. They're using business affiliates to sales to business affiliates instead of majority pricing to calculate royalties, and they do so on the honor system. That is laughable. Oil companies' appraisals are being used for allotted lands to value rights of way, also very laughable. Landowners are not being shown the appraisals. They're not being shown anything. The Department of Interior, as I noted, was misusing the 48 Act as though it preempts the earlier ones. It does not, as I've explained. We have a case, the Leona Gopher case, in which renewal was not available and a new application was required, and Leona's home agency was fighting like a panther to renew. There was a reason for that, and we'll go back and see it in a minute. This is fraud on the court. By using 357 when there is no legitimate authority for a court to create pipelines by condemnation is, I think BIA is complicit. The Department of Interior is complicit with the corporations in misleading the courts. Now, I've already said this. Correction, I'm babbling. Condemnation is not properly used for pipelines. There are two solicitors' opinions that say this. They're from the 1940s. They have never been withdrawn. I think it's 1942 and 1945. The pipeline statute was passed 3 years after the condemnation statute. There would not have been a reason to pass that statute if condemnation were sufficient. 25 U.S.C. Section 321 and 357 are not alternative methods of crafting pipelines. Here's a big word, a term, Inchoate hereditatement. Impress your friends with that. I'll repeat it again. Inchoate hereditatements. That's what an easement is. An easement is not an interest in land. It is a right of user. Title does not change when you have an easement. It's a right to cross. In 357, title changes. The title goes to fee simple absolute. But the corporations are doing something even stranger. The BIA is sending out the consent forms in the blind, attaching nothing to it. It's told to sign in blank. And if they don't get enough, then the corporations turn around and let's say you have 80% consent of the required amount. The corporations turn around and select a number that would of undivided interest that would equate to the 20% missing, and somehow these two in polar opposite interests are supposed to blend by some magic process into a creature that has no name in law. Neither of the laws are complied with, but that is what's going on. Now, as I told you, Chapter 8 creates intangible rights, and Chapter 9 creates the tangible fee interest. What is interesting is how could a corporation traded on the New York Stock Exchange claim to be perform a public service? If it were, their profits and dividends would be given to the public at large. What they do is they claim to be common carriers, and they're using state law. Again, we have an M opinion by the solicitor, which might as well be one of the 10 commandments as far as Indian law is concerned. The secretary decides common carrier issues. And we will see later that there is an exact M opinion, which are very authoritative in the department. Federal courts are effectively partitioning allotments without subject matter jurisdiction. There have been only 3 statutes, one of which is no longer in existence. It was in 25 U.S.C. Section 348. The other 2 absolutely give no authority to a corporation to seek to have a interest in severalty created for a pipeline right away. Now, how are federal courts turning condemnation into divided interest when what they're condemning is undivided? Well, that's the $64,000 question. You can't, unless there is partitionment, and the federal court doesn't have authority to do that. They are, the oil industrial complex is also misusing condemnation as precedent for other condemnations. Federal district court decisions do not have precedential effect. Only circuit courts of appeal and Supreme Court decisions do. But nonetheless, this is occurring. Now, what are the rights of co-tenants? Co-tenants in common when a co-tenant uses more than his or her fair share. You cannot commit ouster, and you cannot, if you make profits in excess of your rightful share, you have to share it with the remaining landowners, tenants in common. That's not being done. I mentioned earlier that there have been 2 wholesale efforts to devalue the entire allotted land base. One was the May 2005 John Widow's report that was secured by Ross Swimmer through the National Business Center. When he got caught doing that, the appraiser sent me the report and I fired it out into Indian country so we could share in the benefits of lowballing. The land definition change in December 2nd, 2008 improperly severs merged improvements from underlying trust land, classifies them as non-trust personal property, and invites the state to have jurisdiction over it. That was unbelievable to me. I could not believe that anybody would do that. First of all, you can't extinguish a tax exemption. And when an asset merges with the land, it becomes realty and has a tax exemption. It is under Choate versus Trapp in 1912 case, you have to pay for the extinguishment of that separate property right. And it's not a property right to land, it's a separate property right. So here is something that needs to be known. Condemnation cannot happen when you have a tribal undivided interest in it without the tribe's consent. You will notice in APRA that even when tribes are parties to agreements as co-tenants, they do not waive sovereign immunity, and they do not, basically, they are not a party to the agreement. Now, I couldn't help myself with this. Oh, sorry, my earring just died. The Leona Gopher case is what the Tara Sweeney was using to try to lowball the Fort Berthold landowners. In that case, no regulations were complied with. A friend of mine and I don't know if she'll mind this, Marcella Giles, we worked with Leona on this case. Tara Sweeney was using this horrible case as a basis for lowballing the Fort Berthold landowners. Not only was she doing that, but Leona herself, in this case in which no regulations were complied with, she was overcharged for records. They charged her $3,000 for 120 pages of records. There were actually 220. The first 100 were free, as were the first 2 man-hours. She had and obtained emails that were sent and were received by BIA local agency staff. One said, "She seems confused. Let's keep her that way." What kind of trustee does that? The superintendent threatened Gopher with condemnation under Section 357. The United States was not condemning land. The corporation was. There is a statute that makes it a misdemeanor to induce someone to enter into an agreement. It's 25 U.S.C., I believe, Section 202. There's both fine and jail time that could be involved in that. Now, I'm going to go through partitionment quickly. The Section 5 of the General Allotment Act, which was 348, has been taken out. It was taken out during the ILCA 2000 and ILCA 2004 probate amendments. 378 is discretionary, and the secretary may partition an allotment for the best interests of the heirs, not corporations, of the deceased. But note this, the secretary cannot do it without the consent of the landowner. Jones v. Meehan, an 1899 case, says that. Don't bother reading the whole case, just go to page 32, because it is one of the most difficult cases to read I've ever read. We have highly fractionated interests in APRA, 2204 subsection C, and tribes may seek partition of highly fractionated interests with the approval of the Secretary of Interior. Notice there is no corporation allowed to sever an interest. Now, our history is repeating itself. This from Indian Territory to North Dakota today is a 150-year trajectory. The first well in Indian country was in Washington County, Oklahoma in 1898, and it was Nellie Johnston. My grandmother's allotment was in that same county, and she had one of those predatory guardianships, and she was deceived out of her oil land. Alaska, oil was discovered the same year, but production didn't begin until 1957, and Prudhoe Bay didn't come in until 1968. Along comes North Dakota, which is basically Oklahoma Indian Territory revisited. You had the Clarence Iverson well near Williston. It came in on April 1st, 1951. So this is, each one of these is simply same song, different verse. Now, again, going to humor, because I would like to throw things at times. What the oil companies are doing, obviously they like money and they don't care for Indian or having Indians own things. They're privatizing gains and they're socializing losses. So anytime they lose money, they turn to the federal government and the socializing losses, but they always keep their private gains, and that is through dividends on the stock exchange. I submit that our trustee, theoretical, has attended the Bernie Madoff School of Fiduciaries. There's two kinds of corruption. There's grift and graft. And the grifter's the small potatoes guy. The grafter is typically political corruption. Let me show you our guy. Ryan Zinke, after he took his personal flag down off of Main Interior Building, he quit because he was the subject of 16 investigations. 16. That beats Albert Fall of the Teapot Dome scandal. And Zinke was replaced by David Bernhardt, who, upon being confirmed as Secretary of Interior, immediately had approximately 4 investigations opened on him. He was playing footsie with the Russians and had just before confirmation, had just severed nexus, but his own company did get a nice little uptick in their profits from all of this. Fractionated allotments are aggregations of tenancy and common interests. Tenancy and common are the natural way that property is held if there are multiple owners. The interests are common divided. So if you have a 10-acre allotment and you have 1/10, you don't have a 1-acre chunk that is yours. Somehow, if you have an undivided interest, you're just one of these little dots in the background, as are tribes. So what is interesting is that the condemnation process is targeting interests of, let's say, 1/10, and the court is somehow making divided that which is undivided. That's not even legal. You can't do that unless there is a physical partition, and the courts do not have the authority to physical partition. Tribes, they're just a co-owner. They cannot be sued, and they have not waived sovereign immunity. So if a corporation is condemned to tenancy and common interest, how does it get divided? It doesn't. So that is going to be an issue that people need to focus on. Now, it's clear that the trustee is consistently either deceiving or allowing the courts to be deceived. Let's look at condemnation. Eminent domain is condemnation, the broad term. And those statutes are strictly construed against the grantee, which would be the corporation. Here's the authority for that. In the 1940s, as I've indicated, the solicitor rejected the notion that condemnation could be suggested as a method of securing to corporations the right to cross allotments. Going back to the first box, the department has spoken regarding condemnation as a substitute or an alternative seeking a right-of-way, and it rejected it. That a condemnation was an alternative to seeking a private way of necessity across land. The rules of statutory construction say that courts are to resolve legal ambiguities in law in favor of Indians. There's no ambiguity. The 321, Section 321, was enacted 3 years after the condemnation statute. There is no right to condemn under 357 for a pipeline purpose. Now, this M opinion, 36095, a 1951 opinion, says the secretary determines what a common carrier is, not the state. Not all state laws apply in condemnation cases in federal court. The common carrier status is to promote the interests of the shippers and the oil and gas industry. It is not in the interest of the Indians or of the government, and such a requirement should not be imposed. That's what the solicitor's opinion said. We're missing this information, and I don't know why the trustee and the tribes and the landowners have not found this provision. It's there to be found. Why does the secretary have this authority? Well, it's the oldest requirement in all of Indian law. Section 25 U.S.C. Section 177 is the final Trade and Intercourse Act that were from the 1790s, and they are the basis of all the Eastern land claims. 348 is the Section 348 and 25 is the allotted land version. There are no valid transactions unless they're secretarially approved or there's an alternative form of approval, and condemnation is not it. Transactions that are not secretarially approved are avoided as a matter of law. United States versus Rickard, a 1903 case. Why would a court be partitioning when the trustee has all the land records and co-owner data? It's this is simply a fiction that has been made up and perpetuated on the courts. And I would say that somebody needs to wake up in Indian country and in the Department of Interior and realize the extent of the wrongdoing they're engaging in. I've already said that opinions are binding on all agencies in the Department of Interior, and solicitors' opinions are routinely given great deference by courts. It will, unless they are unreasonable. And agency interpretation of the laws they're required to administer are considered probably the most weighty of all the opinions and statements about a particular statute. That is it for the rights of way. I realize this was a bounce through and that it wasn't intended to be a teaching video, because I just simply wanted you to know that there are large issues out there that are being missed by everyone involved. Well, with that, I'm going to say goodbye and thank you.